Explain the scope of administrative law. Administrative law is the branch of public law that regulates the organization, powers, functions, and control of administrative authorities. With the emergence of the welfare state, governmental activities have expanded enormously, resulting in a corresponding growth in the scope of administrative law. The scope of administrative law extends to the rule making, executive, and adjudicatory functions of administrative authorities. It also includes delegated legislation, administrative tribunals, and mechanisms for judicial control over administrative action. Legal provision. The scope of administrative law is derived from various constitutional and statutory provisions, particularly Article 14, 19, and 21 of the Constitution of India, which is for protection against arbitrary state action. Article 32 Constitutional remedies before the Supreme Court. Article 226 and 227 Judicial review by High Courts. Provisions relating to delegated legislation, administrative tribunals, and administrative adjudication under various statutes. Essential features or contents. The scope of administrative law includes rule-making functions of administrative authorities, executive and administrative functions, adjudicatory functions, delegated legislation, administrative tribunals, judicial control and review of administrative action. Explanation. Rule making functions. One important aspect of administrative law is the regulation of the rule making powers of administrative authorities in modern governance. Legislatures often enact broad laws and delegate the power to make detailed rules, regulations, bylaws, orders, and notifications to administrative agencies. These subordinate rules help in the effective implementation of legislative policies and provide flexibility in administration. Administrative law lays down the limits within which such rule making powers may be exercised and ensures that delegated authorities do not exceed the powers conferred upon them. Thus, administrative law controls and regulates the lawmaking functions performed by administrative agencies. Executive functions. Administrative authorities perform numerous executive functions on behalf of the state. These functions include implementing laws, maintaining public services, regulating economic activities, collecting taxes, issuing licenses, granting permits, enforcing regulatory standards, and carrying out welfare programs. Administrative law governs the exercise of these executive powers and ensures that administrative authorities act fairly, reasonably, and within the boundaries prescribed by law. It also provides remedies against abuse or misuse of executive discretion. The executive aspect of administrative law is therefore concerned with the day to day functioning of government administration. Adjudicatory functions. Administrative agencies often perform quasi judicial functions in addition to their executive duties. They are empowered to determine disputes, hear objections, conduct inquiries, and make decisions affecting rights and liabilities. Examples include labor authorities, tax authorities, consumer commissions, and regulatory bodies. Administrative law governs the procedure followed by such authorities and requires them to observe the principles of natural justice, including audi alteram partem, right to be heard, and nemo judex in causa sua, rule against bias. Through these principles, administrative law ensures fairness in administrative adjudication. Delegated legislation forms an important part of the scope of administrative law due to the increasing complexity of governmental functions. Legislatures cannot themselves provide every minute detail of law. Consequently, they delegate limited lawmaking powers to administrative authorities. Such delegated legislation may take the form of rules, regulations, orders, notifications, schemes, and bylaws. Administrative law regulates the validity, limits, and control of delegated legislation and prevents excessive delegation of legislative powers. Administrative tribunals, the increased volume of disputes in specialized fields led to the establishment of the administrative tribunals. These tribunals provide speedy, expert, and less formal adjudication in matters such as service law, taxation, labor disputes, and regulatory matters. Administrative law governs the constitution, powers, procedures, and functioning of these tribunals. It also ensures that tribunals comply with principles of fairness and remain subject to judicial review where necessary. Administrative tribunals have become an essential component of modern administrative justice. Judicial control of administration. Judicial control is one of the most significant aspects of administrative law. Courts exercise supervisory jurisdiction over administrative authorities to ensure legality, fairness, and accountability. Judicial review enables courts to examine whether administrative actions exceed legal authority, violate constitutional provisions, breach principles of natural justice, are arbitrary or unreasonable, or constitute abuse of power. The Supreme Court under Article 32 and the High Courts under Articles 226 and 227 possesses extensive power to review administrative actions and protect the rights of citizens. Judicial control acts as an important safeguard against administrative arbitrariness. Importance or significance. The scope of administrative law reflects the expanding role of government in a welfare state. It regulates administrative rulemaking, executive action, and adjudication while ensuring accountability through judicial control. By balancing administrative efficiency with individual rights, administrative law promotes good governance and the rule of law. Conclusion. The scope of administrative law is extensive and continuously expanding. It encompasses rule making functions, executive powers, adjudicatory functions, delegated legislation, administrative tribunals, and judicial review of administrative action. Through these mechanisms, administrative law ensures that governmental powers are exercised lawfully, fairly, and in the public interest. It therefore plays a crucial role in the functioning of a modern democratic welfare state.